Important points by the dissenting judge, Justice Bhat, who's saying that their exclusion discriminates equality code and violates the basic structure. This can't be understood as a free pass, but as a reparative mechanism to have a level playing field. This is an important point that, Anisha, has been made by the dissenting judge here, Justice Bhat. Anisha, in fact, I was talking to you about the opinion of the dissenting judge here, who says that this can't be considered as a free pass, but as a mechanism really to have level playing field.
Well, yes, the dissenting judge, and as we speak, Justice Bhat is still reading out his opinion on the other questions of law. Now, remember, what Justice Bhat has done is that he's given an opinion on all three questions of law, which is regarding whether the amendment is constitutionally valid or not, whether the imposition of such a provision in private educational institutions was valid or not, and whether this is per se discriminatory. Now, what Justice Bhat has said is, while this is a discriminatory provision, because this amendment practices something that is constitutionally prohibited, and I'm quoting the Justice Bhat's opinion here, that my colleague Srishi is telling us from inside the court, that this amendment practices constitutionally prohibited form of discrimination because it has, and Justice Bhat has quoted that the Sinha Commission that was set up to examine the condition of economically backward persons in the country in July 2010 had given a detailed report which says that out of the EWS sections, 37% are SCs, 14% are OBCs, and 5% are of general category, which means that according to Justice Bhat and the Sinha Commission report, the bulk of economically weaker sections also belong to these backward categories, which are the socially and economically backward categories of SC, STs and OBCs, which is why Justice Bhat is saying that what is being described as a benefit is not a free pass, that this kind of an exclusion of these categories violates the code of equality and the basic principles under the Constitution. However, he is also saying that reservation in private institution is not per se violative, and this and I will reiterate this once again, Sneha, that because of all of these three questions that have been considered by the court, the contours of the reservation policy going forward are also going to be greatly affected, because here even Justice Bhat, even though he is dissenting, even though he is saying that he does not agree with the EWS, the way the EWS quota has been created and the fact that SC, ST, OBCs have been excluded from this, he however has said that reservations in private institutions are not per se violative, that these institutions constitute a material resource of the community and the state has a vital interest. So this also means that with all five judges concurring on the principle of state being able to include reservations even in private institutions, this will also affect the contours of how reservation in education and reservation in jobs is going to go on moving forward, because this is going to be an important point of contention by the private schools, etc., who have been questioning whether this economically weaker section criteria is something that can be imposed, because remember, the EWS category in school admissions is already there under the Article 21, the right to education. But here, apart from that RTE, here once again this 10% EWS criteria for reserved seats is also something that is now going to impact the education system in the country, and we'll have to see what the other judges have also said about this particular issue, because all five judges have concurred on this one point, that 50% the institutions, educational institutions, are a material resource of the community. And I'm quoting Justice Bhat here, who has, while he has given a dissenting opinion for the general principle, has still agreed that reservation in education can be done even for private institutions. So now what we are seeing here today is that the EWS quota for the general category for socially forward but economically backward persons has been upheld by the Supreme Court, which is saying that the reservation so far has been only for historically oppressed communities, that are the SC, ST, OBCs, but that also cannot go on indefinitely. That reservation per se cannot go on indefinitely is something that the Supreme Court judges have observed. So now we'll have to see how this verdict is going to affect going forward the reservation policy in the country. What happens here now, because remember, now that this policy has been upheld, it is now for the states and the central government to notify the rules by which these reservations will be implemented in the educational institutions and in the government jobs, etc. So a lot of things now hinge on how this entire system is being looked at by the government, by the courts, and what kind of issues are considered when the state governments and the central government is going to be framing the contours of the actual rules of the policy for implementation. So a lot of these points that we're talking about, Sneha, and my colleague Srishti has just sent us another update that the 50% limit breach was the principal ground of attack. That, and he, at least Justice Bhat has said that the Tamil Nadu backward class amendment was held to be violative earlier, and the view of this bench that the creation of another class over and above has a direct bearing on the challenge in that proceeding, which means that the Tamil Nadu Act that was struck down, that is also under consideration by the court, is also going to be affected by this particular verdict of the Supreme Court, and this is something that Justice Bhat has pointed out in his opinion, that is still being read out by the Supreme Court, by the bench right now. And I'm going to request my cameraman Ankit if he can zoom in and show you the 5 judges are still sitting together. The bench is still sitting there, and Justice Bhat is still currently reading out his opinion. I'm not sure if Ankit is going to be able to show you the visuals from the ongoing hearing, which is also being live streamed by the Supreme Court. So if anybody, any of our viewers wants to hear what Justice Bhat is saying, they can also watch the proceeding. And the visual is, of course, we are also showing the visuals on our screens to our viewers right now. The Justice Bhat is still reading out his opinion on on all of these contours, all of these nuances. But it is a very, very clear verdict from the apex court that the EWS quota has been upheld. 10% extra reservation for economically weaker sections from the general category has been upheld by the Supreme Court, and now the cautions and the observations of the Supreme Court should serve as some sort of guiding principles about the debate that is going to now start in the country regarding the future of the reservation policy, how this reservation is going to be framed, in what contours, because as we've been discussing, at least 3 judges have raised the issue of how long can reservations really last. What Dr. Ambedkar had wanted was reservations for 10 years. But the reservations for SC, ST, OBCs are going on even till now. Justice Bhat, I beg your pardon, Justice Trivedi also pointed out that this cannot be become a vested interest, that it has been 75 years since independence. Justice Pardiwala has also said that the principles by which the identification of persons for reservation is conducted